Kia ora. I thought what we'd do now is just go through that case of Battison and point out to you some of the elements of it and the reason that I thought it would be useful to kind of dive straight into the detail of something in order to illustrate some broader issues, both of how the law operates and specifically how it relates to education. On the quiz, I'm learning this stuff too. I've put a deadline on the quiz. I'll take that off in case you want to have a go at that quiz. I hadn't realised I'd done that. That was just the default thing. And the other thing is that you might have noticed that you got answers wrong. You thought you got right. I've also discovered that unless I use tick the box answers, you have to write in the actual words, unless you get exactly the same words as me, you'll be marked as wrong. So if you write a judicial review and what's written on my answer sheet is judicial review, the machine will mark you wrong. But they're little teething things we'll get through. Anyway, so if you just have a look at the judgment, as I said before, at the front of it, there's the cover sheet, and this has the court in which it was decided. In this case, the High Court of New Zealand, the Napier Registry. It's got the CIV number, that's the internal court code, and then underneath that, it's got the reference 2014 NZHC 1462. Which is what you use to identify this particular case. Now, the reason for having those identifiers is to do with the reporting of cases, because case law has such an important part in the whole legal process. It's really important for the whole system to work that cases are reported and are available for other people to read and consult. And so the whole process of reporting and publishing case details is a really, really important part of how this whole system works. You can't operate by looking at precedents and cases unless the cases are actually reported. So that's the details of the case. And then, as I said previously, Justice Collins has started off with a few pages basically outlining what's here and what his decisions are. So he sets out on paragraph 2 the general issues that are arising from this. He talks about the lawfulness of the disciplinary action the school took against the boy, the lawfulness of the hair rule, and the lawfulness of schools' rules in general that attempt to regulate a student's hair. Now, in paragraph 3, he says, I will only reach conclusions in relation to the first two general issues. And then if you jump right through to the very end, and you look at paragraph 96, this is the paragraph that deals with the general issue, not just of was this school hair rule, the way it was applied, an unfair thing, but is it unfair for schools in general to have rules about long hair, about hair length? And he says here in 96, my conclusion that the school's hair rule breaches the requirements that it be certain provides the school and its wider community with an opportunity to decide whether or not it's necessary for the school to continue to have a hair rule. In considering this issue, the school will need to give careful consideration as to whether or not any hair rule would breach a student's right to autonomy, individual dignity, and his rights to freedom of expression, affirmed by Section 14 of that's New Zealand Bill of Rights Act, often shortened to NZ BORA. I have deliberately refrained from commenting on those issues in this judgment. So he's leaving open the question as to whether any hair rules are a breach of fundamental rights of students. And what he does is he focuses on those specific ones, that is the lawfulness of the action that was taken against the student and the lawfulness of the hair rule that the school uses. And on both cases, the judge finds for the plaintiff, the judge finds that the school did err in its disciplinary action against the student, and that the school's hair rule is unlawful. So he outlines that up to paragraph 7, and then he sets out the plan here. So he's got part 1 as the background, part 2 is the suspension decisions, part 3 is the hair rules. So from paragraphs 8 through to 30, the judge outlines the details of what happened, and then in paragraph 31, he looks at the proceeding that's brought before the court, and he says that Lucan seeks a judicial review of the decisions made by the principal and the board and challenges the lawfulness of the school's hair rule. So judicial review, that's what this is. And judicial review, we'll go into quite a lot of detail about this. This is what the process is. This is the process that is outlined under the Judicature Amendment Act of 1972 that's written at the very top of these proceedings. And it's the means by which any decision of any public body can be called into question and reviewed in a court of law. That's why it's gone to the High Court and not the District Court, because a judicial review always commences in the High Court. And we'll go into a lot more detail about judicial review later, but there's a number of kind of different elements about it that have developed. Some of them that are set out in statute, and others that are developed through cases that have been decided on judicial review. But this is the mechanism, and this is the means by which essentially decisions are reviewed. Generally, what happens with a judicial review is not that there's a whole kind of course of action that's ordered, but that the court will decide whether certain decisions that have been made are lawful decisions, and if they find that they're not lawful decisions, then they will set those decisions aside, or those policies aside. So the questions here were, did the principal fail to comply with the principles of natural justice when he suspended the pupil? Now, a breach of the principles of natural justice is grounds for judicial review, that decisions that are made by Crown bodies need to be consistent with the principles of natural justice. So one of the things we'll be looking at when we examine judicial review is, what are these principles of natural justice? Where do they come from? What do they mean? What impact do they have? The second element was that the decision was unlawful because the pupil's conduct did not satisfy the criteria set out in section 14(1)(a) of the Act. That's the Education Act. So they were the two things. And then if you look over the page on paragraph 34, the challenges that are made to the hair rule, and there's 6 of them that are listed there, that they're contrary to Section 72 of the Act, that they're vague and uncertain, that they're in breach of a law, general law protecting personal liberty or dignity, they're in breach of the New Zealand Bill of Rights Act, they're unreasonable, and they're incompatible with the charter of the school that was operating. That's another grounds for judicial review. If you are failing to operate within rules that you've set out, or that have been set out for you, that you are supposed to abide by. So then the judgment moves on in paragraph 36 and looks at the various legislation and international instruments that have an impact on this. And it starts with this point in paragraph 36, that the Education Act confers on all New Zealand students a right to free state education, and that's a critical thing. That's a critical thing, because what was at issue here was an issue of a suspension, and you know, if the punishment had been something other than a suspension, this might have been different. But a suspension has to be a certain amount of seriousness, because the school is there, the pupil has a right to an education, and so depriving the person of that lawful right to the education can only happen on by serious things. That can't just happen on a whim. And so actually what happens, and this is set out in part 37, is that there was an amendment to the Act brought in 1999 that set out procedures about stand-down, suspensions, exclusions or expulsions. And there's a set, they're listed there. Now, further down at the bottom of paragraph 34, it's pointed out that that the significant change in that legislation was that the principal's decision to stand down or suspend a student had to be based on what the legislation called reasonable grounds. And this is an interesting one because, as one commentator has noted, that's John Caldwell, who's an academic at Canterbury, and has written a lot about judicial review and education, that at the stroke of the legislative pen, this increased the prospects of judicial intervention in school disciplinary proceedings. And why is that? Because reasonable grounds, in a legal sense, has a particular meaning, and is noted in the footnote there. Oh, it's a bit further on, actually. The footnote at the bottom of footnote 28. Footnote 28. That what's referred to as reasonable in a legal sense is often something that's called Wednesbury reasonableness. And this is the definition of what is reasonable that was established in a case from 1948 between Associated Provincial Picture Houses and the Wednesbury Corporation. And this is the case that was trying to, one of the things it was determining was what is a reasonable course of action. And since then, that's the standard that was decided in that case has been followed in other judgments. And so the definition of reasonableness is usually referred to as Wednesbury reasonableness after that cause. And what it means is that reasonable can't just be, I'm a reasonable person, or he thought about it or whatever. It's an objective standard that decisions need to be subjected to. We'll go into the details of that again a bit later. Now, if we move on a bit further to paragraph, let's see, from there where we're talking about from 30, 39, 40, that sets out the legislation and the rules about stand-downs and so on, up to paragraph 44, which kind of sums up this balancing thing that the school needs to do, that a school's board must perform its functions and exercise its powers so as to ensure that every student at the school is able to attain his or her possible standard of educational achievement. The board is, so that's what they're required to do. However, the board is given complete discretion to control the management of the school as it thinks fit, provided it does so in compliance with any enactment or general law of New Zealand. So the legislation gives lawful authority to the board to manage the school and to use its judgment and to do what it thinks fit to achieve those objectives, as long as it's consistent with the law of New Zealand. And so this is where those other legal challenges can come into it. If we move on through now to the actual suspension decision, paragraph 49, and here the judge refers to the reluctance of the High Court to enter into sort of skirmishes over disciplinary proceedings in schools. And in a sense, part of the reason for that is because when it has previously been brought to court, the courts have not wanted to intervene. And the key kind of case in this that they go back to and that is mentioned here is the case of Edwards and Onehunga High School, which was a case heard in 1974 by the Court of Appeal. So it's quite an old one, and it again was about haircutting. Now, in that judgment, the Court of Appeal held that the expression may be considered as injurious or dangerous example placed, so that's the expression in the Act, may be considered an injurious or dangerous example, placed power to suspend a student in the hands of a principal. The Court of Appeal said it would not interfere with the principal's decision that the student's behaviour, in this case not cutting his hair, was an injurious or dangerous example to other pupils, unless the principal could not reasonably have reached that view. So, again, we've got this notion of reasonableness, the Wensbury notion of reasonableness, but essentially that was being, it was decided that as long as it was reasonable for the principal to act in this way, then it was okay to go ahead. Now, the judge goes on and mentions a couple of other cases that have happened since then as well. So in paragraph 51, the judge refers to the case of M and S. Cases are referred to by their names. M and S is because the names of those parties were suppressed for some reason, so it still needs to be referred to by something. And that V in the middle, in American, Kramer versus Kramer. In New Zealand, the V is referred to as and, so it's M and S, not M versus S. And this is an interesting point that the High Court came to here, where it said that that no one should underestimate the capacity of a student to perceive and feel injustice. Therefore, the court had to be concerned not only with a public interest in orderly education, but also with a need to protect the individual child and that child's confidence he or she can receive justice from authority, which is a really interesting ruling that you can't. It isn't okay. It isn't lawful to disregard the need for children to be free from kind of arbitrary decisions. That you need to respect the entitlement of children to be dealt with in a just way from those who are in authority over them. And then he goes on in paragraph 52, and this is particularly interesting. In my assessment, the legislative development since the Court of Appeal decided the Edwards case, Edwards in Onehunga High School, combined with the obligations New Zealand has under the Convention for the Rights of the Children, which I skipped over, but that was mentioned before, and that international convention is an important part of recognising children's rights. New Zealand's a signatory to it. It's not binding, but it is persuasive in a court. And the effects of the New Zealand Bill of Rights Act means that it is no longer appropriate for the High Court to take an approach in student disciplinary cases which fails to give appropriate weight to the rights and interests of a student. Now, this is particularly significant because this judgment is heard in a High Court. And one of the things we'll talk about a bit later is the way the court system works. If a High Court judge decides something, then a district court judge, which is lower down, a district court judge in the same circumstances has to make the same decision. You have to follow the judgment of the court above you. Now here we've got a High Court judge and the High Court judge has a Court of Appeal decision. So the High Court judge can't just go, well, that's what the Court of Appeal thought, but I think something else. The High Court judge, with the same fact scenario, is required, obliged to reach the same conclusion. He doesn't make his or she doesn't make their own mind up about it. They have to follow. So where in this case the judge is wanting to take a differing point of view, they can't say it just on the basis that they think that the Court of Appeal is mistaken. They're saying that that things have changed since then. There have been legislative developments since then, so the statute has changed. There are obligations that New Zealand has signed up to under international conventions, and they are new. And the New Zealand Bill of Rights Act, signed in 1990, the Court of Appeal thing was in 1974, so that's new. So that's the basis for the High Court then saying that there is a different basis for me coming to the decision that I have. And they have to say that, spell it out, because they can't just make up their own make up their own mind on these things. So now they move on in paragraph 55 to the section in the Act, the particular section, section 14, brackets 1, brackets A, that discusses the issue of suspension. And what the judge points to here is that the section does empower a principal to suspend a student, but only when the student's conduct is so egregious that it seriously impacts on the welfare and attitude of other students in the school, to the point where the principal is left with no alternative other than to suspend or stand down the student in question. And he points out the powers contained in this part of the Act are measures of last resort for a principal. So the harm needs to be really serious, and the suspension needs to be a last resort. And he develops that further on too in paragraph 58. Principals must ensure that serious disciplinary consequences are reserved for truly serious cases. And when it comes to suspension, because of those rights to education, and because there are written statutory thresholds about what's required, you can't just suspend somebody willy-nilly. They could have told the kid to come back after school every day for 2 months or whatever, and it probably wouldn't have got to court, or if it did, it might have failed, because that's something that's a kind of a low-level response compared to suspension for that level of activity, that level of offending. On paragraph 62, the judge goes on, second, it's also necessary for those deciding school disciplinary cases to ensure that penalties that are imposed minimise the disruption to a student's attendance at school. And this was not looked at by the principal. So the principal, in reaching his decision, didn't properly weigh up the fact that the student had an entitlement to attend school, and so the punishment needed to interfere as minimally as possible with the student's right to an education. Paragraph 66 through to 79 essentially talks about internal stuff between the principal and the disciplinary committee and so on. The lawyer was trying to find a little bit of wriggle room around who decided what on what basis and so on. And then in part 3, the judge refers to the hair rule, and paragraph 80, 81, 82, and 82 sets out the challenge that I mentioned before, that the hair rule conflicts with the school's charter, that it breaches the common law right to personal autonomy and integrity that's affirmed in this International Convention on Civil and Political Rights, contrary to the Bill of Rights Act, and is uncertain. And here again in 83, the judge kind of pushes aside some of those things, because he's basically ruled that as long as it breaches one of those elements, then the rule can be set aside. So he moves on to talk a bit about the school charter, and in paragraph 88, then he comes back to the hair rule. He says the hair rule is delegated legislation. So this is a rule that hasn't come from Parliament, but it has effectively come from Parliament because it's a rule that the rule maker was authorised by Parliament to make, if you see what I mean. So therefore it must be sufficiently precise to allow students and parents to fully understand the rule's requirements and arrange their affairs without breaching its provisions. So essentially the issue here with the rule is that, irrespective of all the other things, the judge's finding was that the rule lacked certainty. And on that basis alone, without looking at the other criteria, the rule could be overturned and declared unlawful, unenforceable. And you see down in paragraph 91 and 92, there are differing perspectives from different hairdressers about whether the hair is actually short, whether the hair is in compliance with the rule. And the judge makes the point, the fact that there can be diametrically opposed views on whether or not Lucan's hair actually complies with the hair rule underscores the concern that as it is currently worded, the hair rule is prone to subjective interpretation and therefore uncertain. So essentially what he's saying is that a school's may or may not be allowed to have a rule on hair. Well, you know, somebody might want to challenge that under some other legislation. But leaving that aside, if they are going to have a rule about hair, it has to be one that is clear and that there is some objective measurement about whether the rule is being adhered to or breached. And in paragraph 92, he compares the hair rule with a uniform rule. Uniform rule, there's no question. There might be some questions whether you're wearing the right uniform or not, but the rule is clear. You know, you can tell by looking at somebody whether they are wearing the correct uniform or not. The same cannot be said about the hair rule, he says, which is capable of being interpreted differently by parents, students, teachers, the principal, and the board. So that's essentially what was decided, and so on the basis of that, short and snappy conclusion starting on paragraph 97, I issue declarations that the decisions suspending Lucan from the school were unlawful because the criteria set out in section 14(1)(a) of the Act were not satisfied. That is, the threshold for seriousness was not met, that it wasn't used as a last resort, and so on. That the disciplinary committee's conditions on Lucan's ability to return to school were unreasonable. Again, I skipped over that when we were talking about it, but that was part of the decision as well. And that the school's hair rule breaches section 72 of the Act because it is uncertain. And then finally we get to the last paragraph, paragraph 98. Lucan is entitled to costs. On a scale 2 basis, these will be paid by the school board. So who pays for this? Well, you take a judicial review, you pay for it yourself. Judicial review can only happen if both sides play ball. I've been in situations with a educational institution actually where somebody approached me. It wasn't a school, but it was an educational institution. I determined that what the school had done was outside the school's own rules. So I wrote to the school and I said, this is outside the rules, and we could do judicial review, or you could just accept this and we could, you know, find a solution. And they accepted it and we found a solution. And that's generally what happens. And the reason it's generally what happens is because most of these things, there are reasonably established ways of finding out who's right and who's wrong. Sometimes it needs to get tested in court, but the vast majority of the times it doesn't need to go to court. That's why all this talk about schools lawyering up and they can't have hair rules and all that, completely ill-informed, completely ill-informed. But if you do take judicial review or somebody takes it against you, then it means that you haven't come to agreement on these preliminary discussions, and each side thinks that they will win the battle if it goes to court. The consequences of losing judicial review are that your case fails, and you have not only paid to mount your case, but you almost invariably get hit with the costs of the other party as well. And so that's what happened with the school. They had to pay for their own legal case, and they also had to pay for the others. The costs, the financial implications of winning a judicial review are also interesting in that you kind of get your money back because the other side is required to pay for you. But that's it. You don't get awards of compensation or anything like that. You get a ruling about, as we've seen here, a ruling about the lawfulness and the acceptability of various rules or procedures or decisions or whatever, and that's it. So there's no big pot of gold at the end of a successful judicial review, which is good in a way, because it means that there are fewer of them. But it also means that, it's a bit of a gamble, because you've got to be able to front up in advance, and it costs quite a lot of money to mount one of these things. So that's part of the reason why there aren't very many cases around these sorts of issues to draw from. But there are some, and this one, I think, opens a lot of different interesting points that we'll be able to follow up further on with the course.